On February 26, 2024, the Trudeau government in Canada introduced what it calls the Online Harms Act, Bill C-63, which it claims is to make online platforms responsible for addressing harmful content and, wait for it, to create, in quotes, safer, close quotes, online spaces. Almost the entire focus of the government messaging is on protecting children, and the mainstream media in Canada has, dutifully, parroted the government backgrounder, which is in nice, easy-to-read text. One could ask, why wait so long? You've been in power since 2016, but to ask that question would be to assume there is any truth to the claim. There isn't. Almost nothing of significance in the bill has anything to do with children. One needs to scroll about 3/4 of the way down the actual legislation to see the real purpose of the act, which is to amend the Criminal Code and Canadian Human Rights Act to introduce truly Orwellian state powers with the actual purpose of targeting political opponents, silencing political debate, and thus preventing the spread of unacceptable views, and thus maintain the overall progressive agenda indefinitely. Because when it comes down to it, a Western-style democracy, as in Athens, or a republic, as in Rome, or, for at least part of its history, the United States, requires the freedom to accuse and condemn, even to insult, blame, and censure, to be rude, even abusive, as the fuel of political debate. One would have to look very hard indeed to find a case where a hate crime conviction, if it had any merit, and the prosecution was not entirely politically motivated, could not have been addressed by traditional offenses under the criminal law, such as threats to life, health, or property, assault, even murder, or worse, and in the civil law, through causes of action such as libel, defamation, interference with contractual relations, and the like. The hate crime is an offense only a tyrant could love, and the Online Harms Act, and its equivalents throughout the West, is the hate crime regime tyrants love best. The Online Harms Act is, at its core, the antithesis of law. It is anti-law, a pure expression of power. If passed by Parliament, which is to say by the Commons, by the Senate, and given royal assent, this piece of tyranny would allow one person, and not necessarily even a citizen, to report others to a provincial court judge out of fear that they might commit a hate crime or hate propaganda in the future. Who might this complainant be? Perhaps a colleague at work who heard you say something they didn't like. Perhaps a neighbor who didn't like the party you supported last election. Or perhaps, and most likely, someone monitoring your social media. The complainant can of course be anonymous, which anonymity the legislation is at pains to protect. Investigators could enter into your workplace without a warrant and demand access to records. The amendment to the Criminal Code includes fear of hate propaganda offense or hate crime. Section 810.012, subsection 1. A person may, with the Attorney General's consent, lay an information before a provincial court judge if the person fears, on reasonable grounds, that another person will commit A, the offense under section 318, or any of subsections 319, subsection 1 to subsection 2.1, or B, an offense under section 320.1001. Now, section 319.1 is the offense of public incitement of hatred. Section 319.2 is the offense of willful promotion of hatred. Section 320 is the offense of spreading hate propaganda, and allows a court to order its seizure. The first thing you might have noticed here is these complaints have to be state approved. The AG must consent. So right away, hate that the state likes will not be affected. Next, 2. The provincial court judge who receives the information may cause the parties to appear before a provincial court judge. If the provincial court judge before whom the parties appear is satisfied by the evidence adduced that the informant has reasonable grounds for the fear, the judge may order that the defendant enter into a recognizance to keep the peace and be of good behavior for a period of not more than 12 months. The preliminary question is how exactly does one provide or prove reasonable grounds that a person will in the future commit a hate crime or hate propaganda? What evidence does one put before the court to show what this person might do in the future? How do you prove what is in this person's mind? How much more than the accusation itself will be required? And I suspect very little else. In other words, the alleged fear of the complainant and the reasonable grounds are basically the same thing. 5. The provincial court judge may commit the defendant to prison for a term of not more than 12 months if the defendant fails or refuses to enter into a recognizance. So now you're serving jail time for something you haven't done. It gets worse. What are some of the conditions that can be imposed on this person who hasn't done anything yet? The provincial court judge may add any reasonable conditions to the recognizance that the judge considers desirable to secure the good conduct of the defendant, including conditions that require the defendant to A. Wear an electronic monitoring device, B. Return to and remain at their place of residence at specified times, C. Abstain from the consumption of drugs except in accordance with a medical prescription, of alcohol, or of any other intoxicating substance. D. Provide for the purpose of analysis a sample of a body substance for alcohol and drug testing. F. Abstain from communicating directly or indirectly with any person the judge considers necessary. A person may also be prohibited from possessing firearms. The bill would increase the penalty for hate crimes from 5 years to life in prison. Words alone could lead to life in prison. Hate crime, offense motivated by hatred, Section 320.1001, subsection 1. Everyone who commits an offense under this Act or any other Act of Parliament, if the commission of the offense is motivated by hatred based on race, national or ethnic origin, language, color, religion, sex, age, mental or physical disability, sexual orientation, or gender identity or expression, is guilty of an indictable offense and liable to imprisonment for life. As I mentioned, the bill would also amend the Canadian Human Rights Act to specify that posting hate speech online is discriminatory. Communication of hate speech, Section 13.1. It is a discriminatory practice to communicate or cause to be communicated hate speech by means of the internet or any other means of telecommunication in a context in which the hate speech is likely to foment detestation or vilification of an individual or group of individuals on the basis of a prohibited ground of discrimination. What exactly does a phrase like foment detestation mean? The definition of hate speech has been described as amorphous and confusing, and thus potentially quite pliable. And, of course, specialized tribunals are created, removing your ancient right to defend yourself in court. Instead, the new Digital Safety Commission would police content. The commissioners would be appointed by the government and will share its views. A whole new class of hate speech can now be heard and penalized by the Human Rights Tribunal using a lower standard than the criminal standard of proof beyond a reasonable doubt. The tribunal can impose fines up to $50,000, and your politically motivated and anonymous complainant can receive a further $20,000. This same Section 13 had been repealed in 2014 due to public outcry when it was used to target Maclean's magazine and one of their writers, Mark Stein. Apparently, that outrage has been forgotten by the public, by the media, and quite happily by the government. This is another example of the fact the progressive left never gives up. It may back down for a while, but like a bad penny, it always turns up. And the laws the left excretes, no matter how novel, how repugnant to the traditions of a country or its people, no matter how damaging to civic life, no matter how dysfunctional society becomes, we always soon hear that the latest and even more radical reform to achieve utopia reflects fundamental rights, reflects the only correct way to see the world, and is thus sacrosanct in some progressive religious sense, and can never be changed. Get used to it. Italian Catholic philosopher Augusto Del Noce describes the political climate we live in as a merger of the failed Marxist experiment with materialist Western liberalism. The result are regimes in the West that believe in the absolute sovereignty of man, which has driven objective human goods out of public discussion. Regimes like the Canadian one are characterized by relativism, destruction of human connections, a startling emphasis on sexual matters, and a society that delivers exactly the opposite of what it promises. This is awkward, and awkward questions have to be suppressed. People have to shut up. Religion neutered, a comprehensive system of lying established, and scapegoats picked out and persecuted. The Online Harms Act is a finely crafted tool for this purpose in the Canadian context. Bill C-63 will add new layers of legal sludge, clogging the arteries of civic life in a country like Canada. It will further discourage serious political debate, which on the eve of an election in Canada is without question the real purpose of the bill. But let me step back for a moment to the very concept of a hate crime, which is now already well entrenched in Western societies. There's a fundamental problem with it which makes it so deleterious to a state founded on Western traditions, to the extent they still survive. The major flaw with hate crime laws is that they assume, or are designed for you to assume, that the class of tyrants and victims is capable of being fixed, defined, and predetermined by a set historical narrative. Was then, is now, forever will be. Okay, that's nice. But what if yesterday's tyrants aren't the same as today's tyrants or tomorrow's tyrants? A victim group can produce a tyrant in its midst, like any other. To appreciate how significant any limitations are on who can call out a tyrant, consider the classic oration against tyranny. We call this a Philippic, or a fiery, damning speech or tirade delivered to condemn a particular political actor. The term is most famously associated with two noted orators of the ancient world, Demosthenes of ancient Athens and Cicero of ancient Rome. Demosthenes delivered his attacks against the tyranny of Philip II of Macedon. That's where the speech gets its name. Cicero's attacks were directed at a rising threat of tyranny in Mark Antony. It is hard to have an angry tirade without a little hate. A tirade is defined as abusive or insulting language used to express blame or censure, or a form of rude expression or discourse intended to offend or hurt. Vituperation, or deeply seated ill will, vitriol. The Latin adjective invectivus means scolding. Not only does the Online Harms Act further suppress public debate with its terrifying web of amorphous, ill-defined offenses, sanctions, penalties, and secret tribunals, not to mention secondary effects to one being drawn into this rat's nest, such as loss of job, career, status, but it is also the perfect tool for tyrants to suppress their critics. In the West today, it may be that delicate issues need public debate to figure out why exactly the West is in decline. Our cities dying, addiction and suicide, and crimes on the rise, standard of living in freefall, marriage and childbirth rates in collapse, and who knows, perhaps a solution to benefit our children can be found. Hate crime legislation makes that very unlikely, if not impossible. In Canada, for example, the Overton window of political debate is paper thin, fear and conformity being critical factors. But what about the freedom to attack a tyrant in public? The opposition leader in Canada actually raised this concern, if not with much passion.
What does Justin Trudeau mean when he says the word hate speech? He means speech he hates.
Now, I would never say Trudeau could be compared to Mark Antony. As a man, that would be ridiculous. Why would you want to do that? And one cannot compare a speech by Mark Antony.
I come to bury Caesar, not to praise him. The evil that men do lives after them. The good is oft interred with their bones, so let it be with Caesar.
To Trudeau's unique gift for spoken imbecility.
Dumb joke a few days ago that seems to have gone a little viral in the room on the people kind comment. It played well in the room and in context. Out of context, it doesn't play so well, and it's a little reminder to me that I shouldn't be making jokes even when I think they're funny.
But politically, in listening to some of Cicero's attacks on Antony from over 2,000 years ago, you will hear that tyrants like the sponsors of Bill C-63 have common qualities of arrogance and cronyism, a surprising transparency in their real political motives, quick to disregard political institutions and traditions, and even the law, and share a certain stupidity that is often exposed. Cicero considered Antony a threat to Roman traditions, to its laws, to the survival of the Republic itself, and regretted that Antony had not been eliminated by the conspirators when Caesar was assassinated on the Ides of March. Antony's response to Cicero's speeches, called the Philippics, 14 in all, was to have Cicero killed and his hands nailed to the doors of the Senate as a warning against opponents to his new regime. We should consider C-63 a warning as well. In truth, when wicked men, being compelled by the revelations of the accomplices, by their own handwriting, and by what I may almost call the voices of their letters, were confessing that they had planned the parricidal destruction of their country, and that they had agreed to burn the city, to massacre the citizens, to devastate Italy, to destroy the Republic, who could have existed without being roused to defend the common safety, especially when the Senate and people of Rome had a leader then, and if they had one now, like he was then, the same fate would befall you which did overtake them. But you are so senseless that throughout the whole of your speech you were at variance with yourself, so that you said things which had not only no coherence with each other, but which were most inconsistent with and contradictory to one another, so that there was not so much opposition between you and me as there was between you and yourself. However, remark the stupidity of this fellow, I should rather say of this brute beast. Let this stupidity exist in your language. How much greater is it in your actions and opinions? Sleep off that intoxication of yours. Sleep it off and take breath. Must one apply a torch to you to waken you while you are sleeping over such an important affair? What's the matter? Am I embarrassing you? For perhaps you do not quite understand propositions which are stated disjunctively. Shall we then examine your conduct from the time when you were a boy? I think so. Let us begin at the beginning. Do you recollect that, while you were still clad in the praetexta, you became a bankrupt? That was the fault of your father, you will say. I admit that. In truth, such a defense is full of filial affection. But let us say no more of your profligacy and debauchery. There are things which it is not possible for me to mention with honor. But you are all the more free for that, inasmuch as you have not scrupled to be an actor in scenes which a modest enemy cannot bring himself to mention. It is not so much a proof of audacity to advance these statements so impudently, as of utter want of sense to be unable to see their contradictory nature. For what is more insane than after you yourself have taken up arms to do mischief to the Republic, to reproach another with having taken them up to secure its safety? On one occasion you attempted even to be witty. O ye good gods, how little did that attempt suit you! And yet you are little to be blamed for your failure in that instance, too, for you might have got some wit from your wife, who was an actress. Arms to the gown must yield. Well, have they not yielded? But afterwards the gown yielded to your arms. Let us inquire then whether it was better for the arms of wicked men to yield to the freedom of the Roman people, or that our liberty should yield to your arms. Nor will I make any further reply to you about the verses. I will only say briefly that you do not understand them, nor any other literature whatsoever. May the indignation of the Roman people at last bring forth what it has been so long laboring with. In truth, if 20 years ago, in this very temple, I asserted that death could not come prematurely upon a man of consular rank, with how much more truth must I now say the same of an old man? To me, indeed, O conscript fathers, death is now even desirable. After all the honors which I have gained, and the deeds which I have done, I only pray for these two things. One, that dying I may leave the Roman people free. No greater boon than this can be granted me by the immortal gods. The other, that every one may meet with a fate suitable to his deserts and conduct towards the Republic.